Good morning, everyone. Thank you for joining us for Minnesota Matters. I'm Tess Rice, MBA's General Counsel. Teresa Kuvas is here, our Senior Government Relations Manager. She's going to talk about what's going on at the legislature briefly. And then Tom Boswell-Healy and I are going to talk about senior and vulnerable adult fraud. There was a recent Court of Appeals case involving a vulnerable adult that we want to dive into. And also we'll go over some of the resources we have available to help you navigate those situations. This is being recorded and it'll be available on MBA's YouTube channel. All right, I will turn it over to Teresa.
Perfect, thank you. Good morning, everyone. When we last left you at the end of May, the legislative session had just concluded. However, they had not finished a good portion of their budget bills. And so I think we kind of left it with, there was an agreement at the end of session, but they were going to still need to get to a final agreement and then get to a special session with the hopes of it just being a one-day special session. So that did occur on June 9th, so well ahead of the a possible government shutdown. So on June 9th, the legislature came in for a one-day. I think they were done within 20 hours, got through the final remaining omnibus bills and concluded. And so that, that was kind of where things were left off. But, within that week, the world in Minnesota kind of changed. That following Saturday, Speaker Melissa Hortman was assassinated in her house, and Senator John Hoffman and his wife were also shot. So that's really changed kind of what the legislature will look like going forward. And so we are deeply saddened still by that. I still don't know how we go to a session next year and not have Melissa Hortman there. She's been, we didn't always align with her on all of our issues, but she was a great legislator and a great leader. But that kind of gets into kind of, special elections and special election. We've always talked about special sessions not being special, and that they happen quite frequently, but special elections are definitely not special this year. We've already had 3 special elections. And again, just to kind of point out the breakdown of the legislature, the House is a 67-67 tie, and the Senate is a 34-33 DFL majority. So we had 3 special elections within the legislative session this year. One due to an elected candidate not living in the district, and the governor and the judge pushing that one out, and saying he did not live in the district, and so he was not eligible to be sworn in. That one, the governor kind of fumbled the timing of that one, so had hoped to have that one in January, but it was actually in February. We had Senator Dietzig pass away right before the start of session last year, and her special election to fill that seat was at the end of January. So after the special election in February, we were under the impression that we were going to have a 201, seat legislature. Power sharing agreements were finally in place, and I think it was less than 12 hours later when Senator Eichhorn was arrested in an underage sting in Bloomington. And that one ended up resulting in they were ready to expel him the next time they were in session, and he did resign that week. So that then opened up the seat up in the Brainerd area as well. That special election was in April. So finally, for the last 2 weeks of session, we did have 201 legislators. So we briefly had 201, and then we had the assassination of Melissa Hortman. That primary was held last week. That special election will be in September. Most of these seats are all going to stay within the same political party, so I don't suspect that much will change at the legislature numbers wise. Senator Bruce Anderson in Buffalo passed away unexpectedly last month as well, and so his special election, there will be a primary next week, but that one will be filled in November. And then the one that we've all been watching since last April was Woodbury, where Senator Nicole Mitchell had broken into her stepmom's house, had pushed off the court case as long as she possibly could. She was supposed to be in June, but they pushed it to July. She was found guilty. And she tried to give a 2-week notice to resign her seat, but she did finally resign her seat at the end of July. So that seat will also be open for election in November. That one is one that we are definitely watching because the Democrats in that seat, actually both House Democrats on the A and B side are running for that seat. One of them was endorsed. The other candidate said they were going to go on to the primary. So the primary will be next week. But if the Democrat ends up winning, there will be a special election also for the House. So that is kind of some of the wrap up on kind of where we're at for special elections, but then two more just to kind of, just kind of keep in mind also, we have Senator Fateh who is running against Jacob Fry for mayor in Minneapolis. That one could result in a special election as well. And then just a couple of weeks ago, we got word that co-chair of the Commerce Committee, Democrat Representative Herr from St. Paul decided to challenge Mayor Carter in St. Paul. It's both of those for Fateh and for her are kind of, they're races that they can run for, and their seats are not up for election this year, so they're free runs. But if either of them end up winning, there will also be a special election again. Those ones would end up staying within the same party, but could just change the dynamics a little bit. But I think it could all shake out that all the special elections could still occur before the legislature comes back on February 17th. This will definitely hinder any special sessions. I know that Governor Walz had talked about possibly having to have a special session due to anything that might happen at the federal level, but with the uncertainty in all these special elections, they're definitely not going to have any special sessions this year. So that's kind of where we're at for special elections. But as for kind of legislative things that we are watching, this week the Ramsey County District Court ruled in favor with the Minnesota Gun Owners Caucus and struck down the binary trigger ban that was passed in law in the 2024 legislative session. If you remember back in 2024, we had one party control. And part of if we look back, a lot of us like to have amnesia when it comes to sessions. It's how we kind of move forward from session to session. You kind of have to wipe the slate clean. But if you remember, in the last 15 minutes of the 2024 legislative session, again, this kind of goes back to the fact that, Nicole Mitchell's burglary stuff had really kind of hindered the Senate from doing a lot that session because they were really focused on whether she should be expelled or whether she should be voting. That last weekend, Senator Fateh was holding up votes because of Uber driver. He wanted more for Uber drivers. So in that last 15 minutes of the legislative session, there was a 1,400-page omnibus bill that was shoved through over screams in both the House and Senate. It was dozens of omnibus bills. There were, it was paid family medical leave was in there. The Uber bills were in there. There was a lot of stuff, and it was all under the subject of tax bill. The Minnesota Constitution requires laws to address only one subject, and they are clearly stated in their title. That is why that law was struck down this week. That it was less about the actual binary trigger ban. It was more about the process, not the content. So if we kind of, and in Minnesota, we pass omnibus bills all the time, and everybody always brings up single subject, and whether it's legit or not. But this court case really could open up more additional court cases for things that were shoved in that 1,400-page bill. The judge did mention paid family medical leave, the Uber stuff, family tax, the child care tax. There was a lot that was put in there, and it could just kind of open up a lot of lawsuits. Governor Walz has said that he will appeal this court case. I've heard from both caucuses, they like omnibus bills. So I don't know how we get away from doing omnibus bills, but I think that 1,400-page bill did go a couple steps too far. Omnibus bills have been used for last minute negotiations in session. But this is definitely one that could really spark some concern and maybe hesitation when they move forward. But as for legislatively, we're still watching to see what happens with the DFL caucus. They have not appointed a new leader since Speaker Hortman was murdered. And so just kind of how next session goes. We'll obviously have another one of these in November, and also probably right before session starts. So we will have more information coming up, and I will pass it back to Tess for some senior fraud.
Thank you, Teresa. There is some information in the chat of things that are going to come up in our discussion today, but a lot of you know Marty Fleischecker. He was the senior financial fraud ombudsperson at the Department of Commerce. He retired. I put in the contact information for his replacement, Tara Ambrose. I've spoken with her, and she'd really like to do some education programs for us. So she's a great person to talk to. She came from the like the securities side of commerce, and she has experience with the freezing of transactions on that side. So she does have relevant experience. So she should be a great resource. Tom put a link to Commerce's senior fraud resources on there. I have a site to a statute I'm going to mention, and then finally a site to the Court of Appeals case that I want to talk about today. So this decision came out on August 4th. We did put out a legal compliance bulletin on it, but there really is so much in this case. It really is worth getting into the details, I think, because there are a lot of teaching moments for what happened here, and you can get from this some ideas of how to stay out of these court situations. This case involved a dispute between a POD beneficiary on 4 CDs and the estate of the account owner. So the owner of these CDs was named Cheryl, and she lived with her parents for most of her life. She was financially dependent on them. She was considered low functioning by her family, but she had no formal diagnosis of that. Cheryl had 2 siblings, Gregory and Nancy, who did not live near the family. So the situation was a mom and a dad living with their adult daughter, Cheryl. In 2012, Cheryl reached out to a woman named Laura Craig, who lived in Colorado, believing that Laura was her cousin. Laura confirmed that she was Cheryl's cousin. I could not tell from both court cases whether she actually is a cousin. If she is, I think she must be some distant cousin. So those two began communicating, and early on, Laura requested that Cheryl keep their relationship secret. And Cheryl agreed to respect Laura's privacy. Obviously, a big red flag there. After Cheryl's mom died in 2015, Cheryl and Laura's communication increased significantly, and the plaintiff's argument was that happened because Cheryl was talking about the CDs at that point. The CDs were owned by her mom and dad, and they named Cheryl as the POD beneficiary. So Laura convinced Cheryl to put her on as the POD beneficiary of these CDs. And so what she did, so the mom died, but the dad did not die at this point. And Cheryl went in with a springing power of attorney. So a springing power of attorney means that, it becomes effective at a certain point, and it was supposed to become effective when if her dad became incapacitated. So Cheryl, who had not spent much time in the bank, so the bankers did not know her really, she came in with the springing power of attorney and she redeemed the CD, I believe, and made herself the owner, and then listed Laura as her beneficiary. And then the 3 other CDs, she did this after the death of her dad. So she was the POD beneficiary on those, and she just changed it to make herself the owner and Laura as the beneficiary. The CDs had been designated initially by Cheryl to benefit her nephew, and also the family trust. So this is another wrinkle in this case. There was a family trust. It was created in 2009, naming Cheryl as the sole beneficiary. if Cheryl didn't survive to collect the assets, then it was supposed to be split between her siblings. So the parents signed a joint request for retitlement to transfer CDs into the trust and brought that to the bank. But there's no evidence that the bank acted on this request at all. So this is one of those issues. They come in with this form, but it appears that the bank didn't follow through with that. And so the CDs were never put into the trust. So that's going to be one of the plaintiff's issues, obviously, with the bank. So Cheryl's dad died in 2017, and her health began to deteriorate in 2019. And I believe her sister asked for a well check because her brother and sister don't live nearby. And so the police went in, and she's living in very poor conditions. There were dead mice and cat feces, soiled clothes. She was in very bad shape, but she was hospitalized and determined to be a vulnerable adult, likely subject to abuse, neglect, or exploitation. And then she died soon after, within a couple weeks. So after Cheryl's death, 2 days after, Cheryl's sister Nancy, she met with the bank's regional retail manager and expressed concerns about Laura Craig being named as the beneficiary of Cheryl's CDs. And that was followed up by correspondence from the siblings' attorney. He sent 2 letters to the bank early June 19th. So Cheryl's just passed at the end of May, and now early June 19th, within a week. The first letter requested that no funds be distributed due to concerns about Cheryl's vulnerability and potential undue influence exercised by Laura Craig. And then the second letter informed the bank that Nancy had been appointed as the special administrator of Cheryl's estate. So according to the court decision, the bank's executive vice president of retail banking that discussed the situation internally with staff members and instructed the employees not to discuss Cheryl's mental stability with the siblings' attorney unless requested in writing. They know at this point, obviously, that there is a potential court case about to happen, and it makes sense that, they don't want them speaking on this issue. This part kind of blew my mind. So I read every a case that comes out that involves a bank, and when I'm reading this, they start talking about an internal email between the bank and counsel at the Minnesota Bankers Association. It's just like, well, that's never happened before. So they had emailed us, um, let's see, about 2 weeks after they heard from that attorney, because they're wondering what to do, because they don't know if they should be paying out Laura or following, just hold them get the funds as the attorney for the siblings has suggested. So I think this was me. The name was redacted, but so in my email I said, I don't know if the POD's done anything wrong here. There was no indication that they had except for that letter. But if the siblings are fighting about this, then they will get the bank involved with the court action at some point. So I suggested, you should talk to bank counsel. We don't give advice, of course, but and maybe consider doing an interpleader action where the bank's attorney just deposits that money with the court. And the beauty of that is that now kind of the bank's out of it, hopefully, while the two parties fight over the money. So this was actually my email to them came out in discovery and was used against the bank, showing that they had some knowledge that there was perhaps an undue influence issue here. An employee at the bank that didn't know about these internal discussions attempted to locate Laura Craig online, and she found her on Facebook. And she sent a couple Facebook messages. I think she found the husband, Stephen. So she tried to establish contact with Stephen. And the attorney then for Laura sent a letter to the bank asking for the funds to be released. And the bank decided to do that. So they released the funds to Laura late July, citing their obligation to honor the POD designation. So now we got a court case, right? So the case against Laura Craig and her husband involved exploitation of a vulnerable adult and undue influence in getting her to name Laura as the POD beneficiary. Um, and then the case against the bank primarily revolved around negligence and then aiding and abetting the exploitation of a vulnerable adult. So here's what they're saying about the bank. First of all, that first claim was that they failed to transfer assets into the trust. They received the form, but they didn't do it. And then the bank was accused of for assisting Cheryl in transferring the beneficiaries of those CDs that were owned by the Shigas to Laura Craig without proper oversight. So what they're saying is, first of all, the bank allowed her to use that springing power of attorney that was not valid without evidence of his incompetence. They certified documents with a medallion stamp despite suspicions of forgery. I didn't see much more about that claim, so I'm not sure. There are hundreds of documents involving this case, so there's a lot there. And then failing to observe its own policies and training protocols regarding fraud detection and vulnerable adult exploitation. Ignoring communications from the attorney of the siblings who raised concerns about possible fraud and undue influence, and then quickly releasing the funds to Laura Craig. I don't know how quick that was, but despite warnings and internal concerns. And then, so that's the negligence side. And then the aiding and abetting, they claim that the bank aided the Craigs in exploiting Cheryl by allowing her to disinherit her siblings and make Laura the sole beneficiary. And by ignoring those warnings from the attorney and not freezing the assets or investigating further that they had committed this aiding and abetting exploitation. So at trial court, the jury found that Cheryl was a vulnerable adult. So that's kind of a primary step there. And that Laura's designation as the POD beneficiary was the result of undue influence. So a jury had determined that. So the estate was awarded the $250,000 in the CDs, but still going after the bank. So the court just denied the bank's motion for summary judgment on the negligence claim. They thought there was sufficient evidence there to create a genuine issue of material facts. So their key points were failing to follow own policies, certifying documents and releasing funds despite concerns. Then there's the internal emails and testimony from bank employees indicating doubts about how these accounts were handled, and the bank's failure to act prudently as required by the prudent person rule, and its casual attitude towards policies and procedures. So the court allowed that claim to survive summary judgment. The aiding and abetting exploitation claim, they granted the bank summary judgment on. They said the bank, there's no evidence or not enough evidence to show that the bank was aware Cheryl was a vulnerable adult. Remember, she was never diagnosed as such. She didn't spend much time in her bank. I believe her mom did most of the banking. There was not enough evidence to show that the bank knew that the Craigs had done anything wrong. And there wasn't not enough evidence to show that they assisted or encouraged the Craigs. So really, all that happened was an employee reaching out on Facebook, letting them know that there was money to come claim. So, so the bank doesn't survive, or the claim does survive summary judgment against the bank on negligence. A court then found that the bank was not negligent. And then the plaintiffs then appealed the aiding and abetting claim to the Court of Appeals. So not the negligence claim, but the Court of Appeals was the aiding and abetting crime. So, or claim, sorry. So now this Court of Appeals decision that came out August 4th, they did find in favor of the bank. So they said that, and this is really good for the industry, Minnesota law does not provide a statutory cause of action for aiding and abetting financial exploitation of a vulnerable adult. So that's good. Undue influence isn't a recognized tort. Um, Only the Minnesota Supreme Court has the authority to establish new common law torts, so this undue influence um, wasn't a claim that could be made. And then they just found, even if there were, even if undue influence was a tort, the state failed to provide sufficient evidence to show that the bank had actual knowledge of the Craigs' undue influence, or that the banks substantially assisted or encouraged the Craigs in committing the alleged tort. Um, and finally, which was great, the court found that the bank's actions, such as dispersing funds to Laura Craig, constituted routine professional services and did not amount to substantial assistance in any alleged wrongdoing. So the Court of Appeals upheld the dismissal of the aiding and abetting claim against the bank, um, which is great. But when you look at the number of documents involved in this case and you think about the amount of time and resources that the bank had to dedicate to resolving this issue, and the fact that it could still be appealed to the Supreme Court, which will, of course, take more time and more money to deal with. Um, I think it's really important to look at, if you've got a significant amount of money, such as in this case, to again consider that interpleader action and talk to your bank's attorney about it. I mean, you may have great defenses to the claims, but those have to be litigated, right? Some banks will say, well, we've got language in our account agreement and that will protect us. Well, yeah, I hope it does in court, but you don't want to go to court in the first place. Um, I put a link to a Minnesota statute, the Multi-Party Accounts Act, which deals with POD and joint accounts, has language that says that if a financial institution receives written notice or has other reason to believe that a dispute exists as to the rights of the parties, they may refuse without liability to make payments in accordance with the terms of the account. So there is some statutory protection uh, when a bank knows that there is some kind of potential dispute. So I think that's good to know about, but again, not necessarily going to stop things from happening, but it is a defense that you could have in court. Um, let's see, we've got a
Yeah, it's
couple.
good thing to be aware of, even not in a fraud context, just if there's
Yeah, that's
disputes.
right.
I've seen ones where it's a charitable organization. They may not have much money, but there's a dispute among people on the board. So all of a sudden there's two boards or multiple boards that are claiming access to funds and something like that, where the bank can just say, look, we don't know who has the rights to the funds in this account. So you guys are gonna have to figure it out between yourselves and then come back and tell us who's the proper authority on these accounts. And that's unfortunately something that I've seen, multiple times. So
Yeah, yeah. So this is a broad statute. It doesn't have to do with necessarily with vulnerable adults or seniors or anything like that, or fraud. And so it is a nice bit of protection there, but it obviously much better to stay out of court. Um, Tom, I'll turn it
yeah.
over to you.
Yeah, and it certainly underlines the importance of training that frontline staff, and really part of that training, not just outlining specifically what you need to do in every situation, every event that may happen, but just empowering them to pause and go to someone else that may have more knowledge, whether they're going to the compliance officer, operations officer, whomever it is, just if they're not sure what to do, that make sure you're empowering that frontline staff to pause and go to somebody else for assistance, so you don't get into situations like this where maybe they did something that they're possibly pressured into doing by a person in front of them, and whether it's a customer or someone claiming to be a customer, just to make sure that they know that they can take a breath and consider things more carefully. um, and certainly on the fraud or the senior fraud or vulnerable adult in the statute, it's not just seniors, but it's anybody 18 and over. So does have to be an adult, but anybody who's uh, in a facility, or even people that are out, not in a facility, but are, have some sort of physical or mental infirmity or dysfunction. They kind of give all those sort of lawyerly multiple terms for the same thing. So there's kind of that catch-all there. If you don't have a particular person that's inpatient or something that's more formal, you can still deem them to be a vulnerable adult in many circumstances. But it does require reasonable belief um, that some sort of fraud is occurring or has occurred or will occur. So you have to have some evidence there. I can't just, there's got to be something you can point to. There's a requirement for an internal review on that as well. If the bank is initiating it, now if the government's initiating it, then you're just kind of taking orders from the Department of Commerce or the prosecuting attorney, or it could be the local social services body. Um, and that counts. So there you're just taking kind of their order, and the onus is on them to have determined that and provide information that there's fraud that's occurred or may occur or may all those things. So you kind of have the two different things. I think I get see come up too is the exact timing. So when the bank is instituting that hold or delay, you have to notify the parties on the account, unless they're the party suspected of committing the fraud, within 2 business days. And we have a form on the NBA website. You go under legal and compliance, then compliance tools. There's a form out there that you could use to base your information off. And there's kind of some fill in the blanks areas. And then there's also a senior fraud exploitation compliance companion out there as well that has some good information that you can use. But you have after you provide notice to those parties, you also have to provide notice to Mark on that, and then you may provide notice. You're not required to, but you may provide notice to Department of Commerce. It's good to provide that notice to Department of Commerce because they have additional resources that can talk to the customers involved to try to inform them of what's happening and why fraud is being suspected. So, and initially you've got the limit on how long you can place the hold. So the time limit for the initial hold is the 15 business days, and then it can be extended for an additional 10 business days. So it'd be 25 business days total from the initial determination that there could be fraud. And that's something that I've seen from banks. I've received questions where the hold goes on for a longer period of time, especially when it's initiated by the government body, whether it's Department of Commerce or the local attorney, AG, prosecuting attorney, that is, or any of those. And there's not, under the statute, it's really supposed to be a 25-day time frame, but if I was the banker, I would not buck what the government is telling me to do to protect against fraud there and continue that. I would kind of leave that between them. As long as government initiated, the bank is just really kind of the order taker and just kind of doing what they're told throughout that process. So,
What do you do, Tom, when that hold's expiring, you've already extended it, but you still know that that transaction was fraudulent?
yeah, that's where contacting Department of Commerce has the benefit because they're see a lot of this, talk to a lot of people that are involved in are victims of these kinds of events, and the whole idea is to convince the customer to uh, stop the transaction themselves. You convince them that they don't want to go forward with it, so then they'll pull back on the transaction. So it terminates in that respect, just regardless of the hold. The customer decides they won't go forward with that transaction, so we'll stop it. And then the hold ends in that way. It kind of weird. That was one thing that Marty was good about, was talking to these customers and then convincing them that they're a victim of something and not to go forward with these transactions, just kind of pull the back on these transactions. Fortunately, talking to him, he talked often about he would have to go back, talk to the same person with a similar event. It could be as a few days later, weeks later, months later. So it's kind of an ongoing issue and just something to watch out for. Once you have concerns with an account, you're probably obligated to monitor that account more carefully to make sure that other events like that don't happen in the future, and kind of educate your staff on those particular accounts that have had issues, and so they might have issues going forward as well.
So, I mean, at what point, if you have a customer where no one is taking charge of them, no, there's no guardian going to be appointed, but you see that constant, or, it keeps happening, the fraud keeps happening. Um, you're reporting it, but if nobody steps in, I mean, at what point do you see banks close accounts?
I have seen banks close the account, and you kind of follow the statute there. Typically, you want to give 30 days, but if it's something where there's funds are continually not in the account to pay items coming in, you can close it the same day that you provide the notice. Um, it's kind of unfortunate, but the bank really has limited options there. If it continues to be an issue, and I certainly see banks
There
that
is an
close accounts.
option, there's an option in the statute, right, about reaching out to a third party.
Yes, you can't. It's meant to be. There's meant to be a designated third party. That's kind of the framework. So you'd have to, if you know somebody it's maybe a good thing to raise awareness to your customers, especially those if you have some sort of senior club, something like that, saying, you can designate a third person, whether it's a family member or, family attorney, something like that. There's supposed to be some sort of close connection there, but it's supposed to be designated by the customer. Um, that third person so that it permits the bank to contact that person if they see something that may be uh, a financial exploitation. So, but it should
Do
be
you see
something
banks
that's
offering that
documented
now?
on the account. I
Yeah,
haven't seen many that do that.
okay.
I don't think I've had a Minnesota bank mention that they've used that. So I think there's concern about customer privacy. But it is permitted in the statute, so it's not a privacy concern as long as you've got that kind of designation from the customer initially. So that might be the initial hurdle, depending on how vulnerable the person is. They may not be in a state to really identify that person. But
What do you think about the lack of communication in that case? I mean, how do you let your staff know that there's issues with this account and, because that was a problem there. And actually, two of the employees of the bank were named as defendants in that case, so which no one wants to be.
no, no, certainly not. Yeah, that's one of the things. Is just I think it's falls back really just on training, making sure that staff knows that they could talk about this among themselves, um, and raise the issue up to leadership, so that then it's incumbent on leadership to, push the information back down to anybody else who may not be initially involved, so they're aware of what's occurring, what the issues may be, and what actions to take, even if it's just, if this person comes in wanting to do anything on the account, call, so and so, and they'll handle it. Oftentimes that's the best.
So we have a question about, can you stop a transaction if they're trying to withdraw a large amount of cash?
Yes, that would be the same thing. That would be a transaction. Doesn't necessarily have to be a wire or an ACH or something like that. It could be a withdrawal transaction. Just you need to have that. If the bank is initiating it, you need to have done some sort of internal review and formed a reasonable belief that, financial exploitation has occurred or is it being attempted or may occur. So that's as long as you have those, that certainly a cash withdrawal is covered.
Yeah, because we hear a lot about those ATM machines for crypto, where the
Yeah.
customer is encouraged to get cash. I think you put the cash into the crypto machine
Yeah.
and it's converted to crypto.
Yeah. And there's some restrictions on the amount that they could do now in the crypto machines. I think initially it's 2,000 or something like that. So
Is it a 2,000 you can withdraw from a crypto machine in a day? Or, because I'm thinking they deposit the cash into the
yeah.
machine. So I don't know that it would stop them from depositing it, but it would stop them from
of doing the
transferring it
subsequent transfer.
for more than 2,000 a day. A lot of states are looking at that. Minnesota got that one in early, and we've heard good things about that.
Yeah, and certainly cashier's checks are another thing. I mean, cashier's checks and wires pretty much once the transaction is done, you can't really pull them back. You can't put a stop payment on cashier's checks and things like that. So it's really limited circumstances on the cashier's checks once it's issued where you can protect the purchaser of the cashier's check.
We have a
There's
question
something,
about what if
yeah,
the buyer's cash withdrawal is a red flag, but we haven't had any previous concerns on this customer.
yeah. I mean, if you can't, as we were saying before, if you can't get the victim of the financial exploitation to stop, um, there's certainly banks that have closed those kind of accounts. It's just not worth it to have those accounts, and it's really unfortunate circumstance, obviously, but there's no real prohibition against closing that type of account if you cannot get the customer to stop the activity that's essentially aiding and victimizing themselves.
There are, situations where a bank might not have enough cash in their vault
Yeah.
that they could put them off. Obviously, that's a significant amount of cash, but I've talked to banks being able to use that as a little bit of a delay. Um, just, some time to try to call the Department of Commerce or law enforcement.
Right, and that may give you a little time to do that internal review and look back at the account and say, okay, have there been other transactions like this that we're concerned about? And it's really difficult, but obviously some of those it could be relatively small amounts. You're not talking hundreds of thousands of dollars, but maybe 5 or 10. But if you're seeing somebody who used to maintain in their account normally like $80,000, and then over 6 months or so, their cash is going out routinely, and now they're hovering around maybe the minimum balance or a zero, and incurring overdraft or NSF fees, more commonly. That could be an indication that there's financial exploitation occurring as well.
Another question back to the POD topic. What if a POD lives out of the area and refuses to send any identifying information to claim the funds? Is the bank covered if they hold the funds, or are we able to verify the POD in a different method?
Yeah, I mean, I think you have that threshold of identification. If you can't identify who you're paying, there's no obligation to pay out the funds. Um, as for alternative I don't know if you're talking about skip tracing or something along those lines, but I mean, I don't think the bank is obligated to do anything like that. And you would hold the funds, and if nobody comes to collect it, then eventually it's going to be escheated to the state. So
Yeah. Yeah.
there was something in there too about what protections, if any, are there for banks to reach out to family members of potential victims if they're not joint account holders, but we suspect financial exploitation of some kind. And that's what we discussed a little bit earlier. So you can have a designated contact where you can go and talk to, typically it's family members, could be a friend, but those have to be designated on the account in some manner. So it can't be, I really don't think the bank is protected to identify, well, we know, so and so, their daughter Mary, we know, they're not on the account, but we'll talk to them and raise this issue, unless they're a, designated point of contact. I really don't think the bank should be doing that um, without that protection, because then you are protected you're specifically permitted to release information to them about the suspected financial exploitation. But absent that, you know,
Yeah,
I
I
don't
mean,
know.
and you got to weigh those things too, and maybe you talk to the bank's attorney about it. I mean, you really got to think about what the risk is, who's going to have a problem with it, right? Well, your customer in that case may have a problem with it, right? That
Right.
you violated their right to privacy. Um, but obviously the fraudster shouldn't be a concern. There's a question, if we've already gone to Commerce, reached out to a third party, officers are unable to help because the individual does not want help and they are in sound mind but want to continue to keep in contact with the exploiter because they like their company. Do you recommend we close their accounts? We don't know if the person they're sending money to is involved in illegal activity or other obvious exploitation, but does this put the bank at risk, leaving accounts open knowing they are being exploited and we have exhausted all options? I think it does.
Yeah.
I think
Yeah.
it
I think at
really
least
does.
the case that you just talked about, that's
Yeah.
kind of what the bank was being sued essentially for not doing enough. I mean, at this point is in the bank's favor, but that's you don't want to rely on, well, we'll be fine once we go to court because that's expensive and you never know what the district court is going to do. And then, you just don't know what's
Yeah.
going to happen.
In that case, the bank did not know there was exploitation. I mean, that was determined by a jury, but it was not clear at all, and there wasn't a reason for the bank to know that really. But in a situation where you do know, or you're pretty sure that it is, you're not going to you can't rely on the court finding in your favor in that situation. I mean, the facts in that case were better than this.
Yeah. And then let's see. Good confirmation that the $2,000 maximum daily limit for new customers at the crypto ATMs. And then there's one at the end. I think it's the last one there about the bank had a POD that
Yeah.
wanted to assign funds from the accounts of their POD on to their children to avoid tax liability. And can POD transfer funds to another person? I mean, I think they could have the bank, if they wanted to direct the bank to issue checks to other people, but I think it still gets paid out to the POD first, just whether that's just a paper transfer or not. But I don't think you would skip the POD. You kind of have it you
Right.
payable to the POD, and then the POD could do whatever they want with the funds at that point.
Yeah, I don't think there's like a mechanism to disclaim that. I mean, you do see that in inheritance situations
Right.
where a parent might say, "No, don't give it to me. Just go straight to my kids." It is the weirdest
Yeah,
request.
it
Yeah.
is where, yes, you don't often see people turning down money. Uh,
No, no.
Even if it's a little amount, but yeah, I mean, I think it's even if it's a paper step, for the bank, you have it paid out to the POD, and then if you document the POD's request to send checks to, whomever, I mean, I think you could do that, but it would still show payment to the POD and then documenting the POD's direction to send those funds elsewhere. So that wouldn't help
Yeah,
them tax wise.
no, no. Maybe a good problem to have, but yeah, I don't know of a
Yeah.
mechanism to do that. It is interesting. I wonder if any states have something like that. The act
Yeah.
that we have, the Multi-Party Accounts Act, is a uniform act, so most states should be substantially similar, but it's possible there could be a mechanism in some states to do that.
Yeah.
Um, Here, there is a
Oh,
disclaimer
here
that
you
can be
go.
used by the POD to skip them and pass it on to the others. Um, so a
Yeah.
disclaimer form sounds
Yeah,
like I'm wondering
that
if
might be in
that's
the
in.
Multi-Party Accounts Act, then I would imagine. Big.
Yeah, I mean, because it does make sense.
Yeah, because as you say, you can do it in other circumstances, but 6 months after
Yeah.
death, so we couldn't honor it. There you go. Clarification from the other bank.
Okay.
So the request was made 6 months after the death of the account owner. So
Okay. It was that in the statute. I
yeah, so I
wonder.
was trying to.
It's not coming up as I'm not seeing it in a quick Google search, but
Yeah, that's. I was doing the same. Yes.
yeah. Yeah, always interesting when they don't want the money. Anyway, if you want to go back and look at the bulletin we issued last week on that case, or just read the case for yourself,
There we go.
it's very interesting. Oh, it's the Uniform Disclaimer of Property Interest Act. I have heard of that. Yeah,
Yeah,
yeah.
all these
Maybe
uniform
we'll do a
laws.
little bulletin on that, on how that can work with the Multi-Party Accounts Act. I'll take a look at that.
Yeah, that's a good one, but good information to know. Oh,
Yeah, thank you for that, Lynn and Shannon. Okay, I think that's it for questions. So, again, if you want to check out that bulletin or the case, it's probably a good idea for your staff to have some training on these types of issues, or more training. I mean, obviously these bankers did have training, and it didn't really work out for them
yeah.
there, but let's hope that it doesn't get appealed to the Supreme Court and that the bank can be done with this situation. Um, uh, Feel free to contact us anytime, legal@minbankers.com. Can you post a link to the bulletin? Yes, yes, I think we can. Are you able to do that, Tom?
Yeah, I'm getting there.
They're under the legal tab on our website. Um,
Oops.
yeah. If you don't receive those bulletins, you can go onto our website and sign up for any of the bulletins that we put out. We do a regulatory watch one too that contains all the latest changes in the regulations. It's not the most scintillating, but there you go. Tom's got a link in there.
Yeah, that's the link to all the bulletins, and it's the top one, August 12th.
Okay, okay, good. All right, thanks for doing that. Thank you all so much for joining us. I hope you have a great rest of your day. Thanks to Tom and Teresa, and have a good day. Bye.